Hi, I'm JD Hoovener, your host of the Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily dose of inspiration to make the world a better place. All right, everybody. Well, this is part 4 of a series talking about what you should think about before you move forward and hire a patent attorney. Way back on Monday, we talked about looking at all the different upfront legal issues in terms of the statutory bar. If you've got any issues in terms of whether your product is not even really marketable, given the overall industry is kind of sagging. We talked on Tuesday about the idea that this may not be the best fit for timing, and it may be a better alternative to think about as a trade secret in that aspect. So we also looked at when you get ready to prepare for a consultation, what should you bring? All right, what are the things you should get ready to bring in terms of your photos or drawings or images and your prototype? If you've got that, you should bring that too. Today we're going to talk about what actually happens in the consultation, what you can expect, and how to make the most out of the consultation that you have. With our firm at Bold Patents, you get 30 minutes, and it's at no charge. Not all firms are willing to do a free consultation. At our firm, we believe strongly in education. Patent law is one of those areas that many people are interested in. They're kind of intrigued at the idea of creating new things, and the government giving a 20-year monopoly. And so it's a really interesting subject matter. Because of that, so much has been written about it. And unfortunately, so much incorrect or misinformation has been out there. On top of that, the laws have changed so much in the past 10 years that anything written 5 to 10 years ago is really going to be old law, even if it was accurate at the time it was written. That's why it's so important for us to talk with inventors, business owners, and entrepreneurs like you to educate you about the process, help you understand the nuances of patent law and how it applies to your specific invention. So in the consultation, one of the first things you're going to talk about is confidentiality. And you get right up front a clear definition of the fact that you're talking with a patent attorney licensed in a state where they have sworn an oath to maintain confidence. And so that's you should just sort of take a breath of fresh air and realize that this is actually a nice thing, that you can be trusting. You can really get into all of the details. Yes, all of the details. Because every single little detail is going to count. And you're going to want to tell the attorney all of your invention. Because in order to discern whether it's eligible or whether patenting is the right route for you, to get a good recommendation, you've got to tell all. And come prepared, like we talked about yesterday, with a full description, whether it's a written description, drawings, pictures, or the actual prototype. Bring it with you. These are things you can do to bolster and make the most out of a consultation. You're going to want to talk to your patent attorney and inquire about whether they think you have one or more inventions and what that's going to mean in terms of budget. A lot of times we have an inventor come in with their invention, and oh my gosh, what they've got is at least 5 separate inventions that are distinct, and they operate and have different attributes that go on top of one another. So we've got to be proactive and think about, okay, well, which one of these applications, which one of these inventions are we going to want to move forward with first? And so having that business plan, right, that other thing you're supposed to bring to the consultation will help guide this conversation. Where is your business at now? Where is it going to be 5 to 10 years from now? That will help guide an answer as to which invention you move forward with first. You want to discuss different options and what the first step should be. As we talk about in previous sessions of the Bold Today Show, I emphasize the importance of a patentability search for almost every type of invention, especially if the inventor is coming up with this new product that's outside of what they do on a day-to-day job or what they do for work. This is a new field for them. Because of that, they likely don't know what the standard, what the state of the art is. And so that is something that should be looked into by a registered patent attorney, because they need to be able to know what the law is to determine whether that specific reference or prior art is going to be enough to reject the inventor from getting a patent application granted at the patent office. The patent attorney, in essence, puts themselves in the shoes of the examiner. The next big thing you should discuss within a consultation is the process. You've got to be able to come away with a clear understanding of what's next, what comes after, and what leads up to the finish line. And don't forget to ask how much it costs, okay? It's sort of the obvious question, but you've got to ask not just what the first step costs, but what the whole process is going to cost, so that you and your investors know what you're looking at without really batting an eye, or without, with eyes wide open, I should say, as to what the cost is going to be and what the investment is. Hope this has been educational, and hope you all sign up for a free consultation. I welcome you all to visit our website at boldpatent.com. Please forward this email to someone that you might know that's interested in moving forward with their invention. Invite them to go to our website and book a free 30-minute consultation. I'm your host, JD Hoovener of the Bold Today Show. Have a good day, everybody. Go big, go bold.